Hey folks, Turbine Guy coming back at you. Now, as promised today, we're here to do part 2 of the legal filings against Paul Berquist, Benjamin Wilson, and Superior Dreams LLC. And this update, or this legal reading, I guess, is brought to you by Bayside Marine in Excelsior, Go Green Energy, my company in Twin City area. Don't forget about any of us. We're the ones bringing all this to you. Now, this case, 27 CV 22-1089, is public record, and anybody can find this stuff if they know where to look. Well, this complaint is a civil complaint, and it's a civil tort. It could have been criminal because they're going against him for nuisance. So it could have been criminal nuisance, civil nuisance, whatever. So Hennepin County, for its complaint against Paul Berquist, Ben Wilson, and Superior Dreams, by and through its undersigned, states and alleges as follows. Introduction. This action has been brought to remedy the civil nuisance and dangerous situation created by defendants on or about December 15th, 2021, and continuing through the present date, wherein defendants moved their yacht named Seanote from Lake Minnetonka to a boat access in Spring Park owned by the county, Hennepin County that is, where the yacht currently remains in a small sloped parking lot of access while holding approximately 200 gallons of fuel. Despite repeated requests by county of defendants to immediately move the yacht from county's boat access, defendants have failed to move the yacht, thus creating dangerous circumstances, as the yacht is not seated on a proper trailer for the design of the yacht and is positioned on a slope, not level ground. I'm sure Paul would have moved it if he could. And from what I understand, Paul's wanted to move it all along. Hennepin County Sheriff's Water Patrol has determined that the yacht cannot be transported on the current trailer but must be moved onto a trailer which meets all legal requirements to move the yacht legally and safely to a marina. Water Patrol has issued multiple parking tickets and multiple citations for criminal nuisance to defendants. So that brings up a question here. Why are those not included? This is a civil claim. Is he going to have to go through, or all of these people are going to have to go through criminal as well? So they've got to do criminal and civil, maybe. I don't know. You would think that any parking tickets he has, and if I was Paul, I'd be asking, look, Your Honor, this all got to get wrapped together, you know. So defendants' actions pose an extreme risk of injury if the yacht were to topple, creating a danger to Lake Minnetonka if the fuel were to spill, and creating a substantial obstruction to the free use of the access. Now, I'm not sure if it's creating a substantial obstruction to the free use of anything right now. Nobody's parking there. Everyone's out on the lake. Parties. Plaintiff County Hennepin is a political subdivision of the state of Minnesota. Upon information and belief, defendant Paul Berquist is an acknowledged owner of the yacht, a person who brought the yacht to the access on approximately December 15th, and the owner of the trailer upon which the yacht currently sits. Upon information and belief, defendant Superior Dreams LLC has title to the yacht, although the yacht is not registered in Minnesota. Upon information and belief, defendant Benjamin Wilson is an owner of the yacht and the sole name holder for Superior Dreams LLC. That's how they tie it together. I guess that's how they get to all three. Plaintiff has all rights and powers vested in the counties pursuant to state chapters, blah, blah, including the power to sue as provided in Minnesota Statute 373.01. This court has jurisdiction over plaintiff's case pursuant to Minnesota Statute 484.01, Subdivision 1.1. Venue is proper within this district pursuant to the Minnesota statute section. That venue is proper. I'm not sure. I'd be asking for a change of venue. I mean, I don't know how you don't have biased witnesses when it's a Hennepin County sheriff testifying for Hennepin County and Hennepin County's prosecuting. Seems a little too cozy to me. Factual allegations. See how good they did today. Hennepin County owns and maintains 2 boat accesses on Lake Minnetonka. One located at 4141 Shoreward Drive in the city of Spring Park, Hennepin County, state of Minnesota. The yacht is approximately 58-foot vessel, which weighs likely 45 tons, but in the range between 30 and 50 tons. It has been on the lake for approximately 25 years. Used as a charter boat and previously stored during the off-season at Tonka Bay Marina. Tonka Bay Marina was unable and unwilling to store the yacht for this winter. On approximately December 15th, defendants brought the yacht to the access and onto the access boat launch where the yacht substantially blocked access to the lake by other citizens. Actually, it did not. The lake was iced over, and the sheriff would tell you at that point the ice wasn't safe. So even though it was sitting in the middle of the access, I don't think it was really blocking or preventing anybody from doing anything. On approximately December 23rd, defendants moved yacht to another location at the access parking lot where the yacht has remained. Defendants did not seek prior permission from Hennepin County to move the yacht onto the access, block access by the public lake, nor store the yacht indefinitely. I don't think anybody who uses that landing for boats, for snowmobiles, for trucks, for fish houses, I don't think anybody seeks permission to use the access. It's a public access. So that doesn't really make sense to me. The Water Patrol has repeatedly asked defendant Paul Berquist to remove the yacht from the access. Well, sure they have. And Paul's been wanting to move it. The yacht is a V-shaped hull. They got it wrong yesterday too. Hull. H-U-L-L. Not H-A-U-L. V-shaped hull design resting on a flatbed trailer, which is very dangerous configuration as the yacht is unstable even though supported by approximately 15 braces, approximately half of which are exhibiting signs of buckling. We went over this yesterday. Are they buckling, which is a verb, meaning that the boat is currently falling over? Or are they bent, which is a noun, meaning they're bent and the boat is stable? Okay? They are bent. There should be a noun attached here, and I think the word buckling is very disingenuous to be using in this circumstance. The yacht is on a slope, which makes it less stable and more susceptible to tipping. Yes, potentially. The yacht contains approximately 200 gallons of fuel. Due to the dangerous situation, the county has been forced to erect cement barriers around the yacht to help protect the public. The Water Patrol and state commercial vehicle inspectors have determined that the trailer fails to meet the numerous state requirements for transportation of a boat the size of the yacht. Well, I'm not surprised. There aren't many trailers around here that are roadworthy, licensed with lights and everything, inspected and ready to go. And that's the problem. There aren't trailers around here to do it. The Water Patrol and state commercial vehicles, let's see. Oh, I think I read that one. The Water Patrol and state commercial vehicle, no, I didn't, have determined that the trailer is not roadworthy and is in violation of state laws. The trailer contains an unsafe load. Any attempt to modify the trailer would occur in the area of the lake access and potentially result in the yacht toppling and crushing anyone and anything underneath it. Well, yeah, it wouldn't be under, it'd be to the side of it. The Water Patrol and state commercial vehicle inspectors have determined that the trailer cannot be modified to meet state requirements for transportation of the yacht, regardless of whether the yacht is 50 tons or 30 tons. The Water Patrol and the state commercial vehicle inspectors have concluded that the yacht must be moved onto a legally sufficient trailer to transport the yacht legally and safely from the access. Defendant Berquist has acknowledged there's approximately 200 gallons of fuel in it. If the yacht were to topple, residents could be injured or killed. See, if the yacht were to topple, 200 gallons of fuel and oil could flow into, well, more fuel, into Lake Minnetonka, polluting the water. County personnel have examined the access lot, which is currently covered by snow and ice, and noted some damage to the asphalt surface, but cannot determine the full extent of the damage. Yeah, there's some scrapes in it, but there really isn't a lot of quote-unquote damage. Count 1, civil nuisance. Plaintiff restates and realleges the foregoing as if fully set forth in herein, meaning everything I said above still counts. Plaintiff is the owner of the access located within the municipal boundaries of Hennepin County. Plaintiff and its citizens have the legal right to fully use and enjoy the access without risk of injury. That's actually fun. If you've ever been to a boat launch in the summer, you'd realize how silly a statement that is, because let's forget about the Seanote. People do a lot of stupid things with their boats on the access. Okay, defendants act to bring a 45-ton V-hulled yacht onto the access owned by plaintiff and leaving the yacht on the sloped access parking lot for an ongoing and indefinite period is very dangerous to the public, injurious to the health, and indecent and offensive to the senses, interfering with citizens' comfortable enjoyment of life. What? Indecent and offensive to the senses, interfering with the citizens' comfortable enjoyment. They kind of had me going here. You know, I wouldn't go very deep, but it could be dangerous to the public. It could be, but indecent and offensive to the senses, interfering with citizens' comfortable enjoyment of life and property. Not quite sure how that applies. Plaintiff has not given defendants permission to leave the yacht at the access and repeatedly demanded defendant move the yacht to a different location. This is really interesting. Usually when you leave a boat or something like that, there you get tickets. And you go to criminal court and you deal with your tickets. Here, they're playing a different game. If they're really so upset with the boat, why didn't they just tow it away? I don't know. Defendant's act of leaving the yacht at the access, thus forcing the county to erect cement barriers to protect the public as best as possible, has reduced the availability of parking spaces from 9 general parking spaces to 1, and consequently created an obstruction interfering with the comfortable enjoyment of life and property. Nobody uses those in the winter. Everybody goes on the lake. So I don't really think they're blocking anything. Minnesota statute section 561.01 provides that obstruction to the free use of property so as to interfere with the comfortable enjoyment of life or property is a nuisance. An action may be brought by any person whose property is injuriously affected or whose personal enjoyment is lessened by the nuisance. And by the judgment, the nuisance may be enjoined or abated, as well as damages recovered. This is extremely vague and extremely subjective, which is a problem I found with Minnesota code. They write it so doggone all-encompassing. You know what? Me parking my truck there for a day, someone could claim, is obstruction to the free use of the property. But what gets me here is an action may be brought by any person whose property is injuriously affected. County isn't a person. They state that up there. They're a political subdivision. So I'm not sure how a county brings a private nuisance claim unless they're going to try to prove that they're a person, which I know Hennepin County is not a person. Defendant's actions constitute an ongoing violation of 561.01, and that the presence of the yacht at the access has been and continues to be injurious to health and indecent to offend. That's all a matter of opinion, because it's not injurious to my health. It is not indecent and offensive to my senses. I live in Hennepin County. So that is a subjective point. Once again, it's very, very vague. An obstruction to the free use of the property so as to interfere with the comfortable enjoyment of life. And that boat being there has not obstructed the free use of anyone lately. Hennepin County has been damaged and will continue to be damaged by defendants' nuisance in an amount to be proven at trial. In other words, an amount to be proven at trial means we can't quantify what our damages are at this point. Talk about an open-ended lawsuit that's subjective. I thought lawsuits couldn't be subjective. They had to be factually based. Count 2, trespass. Plaintiff restates and realleges the foregoing as a fully set forth herein. In other words, everything above counts. Plaintiff is rightful owner and rightful party in possession of the access. Defendant unlawfully trespassed. Actually, he did not unlawfully trespass. It is completely legal to use that access for boats and trailers, in that he delivered the yacht to the access and continues to store the yacht at the access despite repeated demands by plaintiff to move the vessel to another location. Hennepin County has been damaged and will continue to be damaged by defendants' trespass in an amount to be proven at trial. Once again, we don't know how much we're going for. It seems to me like a lot of this is premature. Plaintiff restates, count 3, ejection. Plaintiff restates or realleges the foregoing as if fully set forth herein. Everything above counts. The common law tort of ejection can be maintained only against a person in possession by one having a present exclusive right to possession, meaning the county owns it. Whoever owns the land can do something. Plaintiff, as fee owner of the access, is entitled to present and immediate possession of the property in its entirety. Entitled to. It is. Not, what do you mean entitled to? Defendant's continuing possession of the portion of the access by the occupation and use of 7 of 9 general parking spots. Now, 8 spots including the placement of a private concrete barrier. Okay, so 7, 8, they're changing, is wrongful and unlawful. Please show me the law that says he can't park there. I have not seen a law or statute presented that says he cannot park there for an extended period. Plaintiff is entitled to immediate injunctive relief, ejecting defendant from the county property, ordering defendant to restore full possession in the county property to plaintiff, and to restore the property to the condition prior to the... Sure, fix the parking lot. Okay? I don't know how they're trying to say Paul has taken this property away. He's done nothing of the sort, or the Seanote. The Seanote is merely on a trailer. The property still exists, and it's still Hennepin County. Wherefore, County of Hennepin prays for judgment as follows. In order for injunctive relief directing defendants, now we went over that yesterday, to cease and desist from storing the yacht on county property and to immediately remove the yacht from its current location. In order permanently barring the yacht, regardless of ownership, from entry onto any Hennepin County access. Sounds like targeting to me. I don't know how you can target one specific vessel or vehicle. Damages for boat storage fees as calculated by an average of storage charges at nearby marinas for a similar sized yacht. They don't say anything about that up above here where it counts, okay, and all the factual stuff. I don't see anything presented that shows that the county has a right to collect fees for people storing boats or yachts or vehicles at county property. I don't see that they're pointing to a statute. Damages for harm to the access. Damages for other county costs and disbursements. Compensation for reasonable attorney fees is allowed by law, and such other and further relief as the court deems just and equitable. They always throw that one in. I don't know why, because almost nothing ever comes up. And this is the best part. Plaintiff Hennepin County hereby requests trial by a jury. I would want a jury. I would want a jury of people like you sitting up there who I can explain reasonably to what's going on and get you to understand, help you understand that I guess, okay, I'll tell you what Turbine did. My Turbine guy's opinion. This is really weak. This whole complaint here, really weak. It says up here that a person, where does it say that? That a person, whatever. It says up here that a person can file a nuisance charge. Well, a county is not a person, it's a political entity. That's one issue. County attorneys do not point to any statutes that give them the authority for any of this. There's not a statute that they're pointing to that says you can't park the boat and trailer there overnight. In fact, there's no signs posted. There's nothing posted saying he can't do what he's doing. It is free and easy for everybody to use that access. Nobody asks permission to use that access, whether it be the summer or the winter. It's just not how it works. And to say that these guys didn't ask for permission is really kind of silly. Targeting the Seanote specifically, saying this boat cannot use the Hennepin County access again, makes no sense. They point to no load standards. They point to no weight restrictions. They point to no statutes that say they can pick or choose one kind of boat or another. If they were going to do something like this, the county has to pass statutes. Okay, this isn't up for the judge. I mean, the judge will probably decide whatever he wants to, but it's not up for him to decide how this should work. This was not regulated. If it's not regulated, then they don't have a lot of stuff to stand on, the county. And that's the thing that confuses me about this, is how they're doing that. Now, we get back down here to the very end, and they say damage for boat storage fees is calculated for a marina. Please, Mr. Prosecutor, can you please point to a statute that Hennepin County or the state of Minnesota has which states specifically, or even generally, that, remember, a statute or ordinance, that the county has a right to collect fees for storage on an access. And the way they're going to collect the fees is use a commercial rate at a marina. It's not how government works. When you go to get a building permit, when you go to get a party permit, when you go to get anything from the city, they have an outlined fee schedule, what things cost. Okay? There's no fee schedule attached to this. They're just making it up. So, harm to the access and all that. Turbine Guy's opinion is that this second part of the legal filings, yesterday's about getting the injunction, and today's about civil public nuisance, are really grasping at straws. I don't see a lot of strength behind any of this paperwork here. I'm just an average person reading this. I'm not some big lawyer or judge, but it's fairly easy for me to see that they're grasping at straws. They don't know what to do, so that, hey, let's grab a real vague civil statute. While we keep piling on the criminal tickets, we're going to go this route and try to get that boat out of there. A little frustrating to me, being a lifetime resident and knowing the history of the boat and knowing Paul and everything that's happened, that the county isn't trying to help. But then, government entities don't know how to help. That's the one thing I found out. Government entities don't know how to say I'm wrong. What government entities know how to do is to hammer you over the head with ordinances that apply or don't apply and let you pay to settle the dust to prove they were wrong. Very dishonorable. Not saying this is dishonorable. I'm just saying they're grasping at straws because I don't think they got much to stand on. That's a Turbine Guy's opinion. Turbine Guy is going to be at the hearing tomorrow, potentially recording it for everybody to see. I'm going to be there as media, so I will do a video after that and let everybody know how it went. I'm sure a lot of people are standing on their seats. And let's just hope that the judge sees how important this is to the public. Because I know y'all want to see this. In fact, I got a call today from Minneapolis St. Paul Business magazine. They're doing a story on this afternoon. This is blowing up. People are seeing it. People want to know. Heck, the county prosecutor's in and they even got Freeman's name on it. This is big news in a small town. This is big news that could be solved. But I think there's a better way to solve it than doing this. Turbine Guy, signing off.